The perjury case against former public protector Advocate Busisiwe Mkhwebane has been postponed to April the 25th next year. Mkhwebane made a brief appearance at the Pretoria Magistrate's Court this morning, where she faces charges of lying under oath regarding meetings with former President Jacob Zuma. The case relates to her controversial findings in the ABSA-Reserve Bank matter, where she recommended changes to the Reserve Bank's mandate, a report she later lost with costs at the Constitutional Court. To further expand on this, we have Legal Analyst Advocate Abigail Ngobene. Advocate, thank you so much for your time today. Welcome to SA Today. So this case comes at the back of a very hard week on Advocate Mkhwebane's part, where her bid to get her 10 million rand gratuity was actually dismissed this week. So for better context, Advocate, let's start here just by revisiting what the actual merits of this particular case actually are, and where did the charges actually emanate from?
Well, good afternoon to you, Alicia, and good afternoon to the viewers of SABC. And thank you very much for having me. Of course, this particular matter has its genesis from what you have just said, to say initially there was a report that was compiled by the former public protector relating to the ABSA matter and the Reserve Bank. But of course, as you remember, that she was later ordered to pay costs on an attorney and on-client scale from her personal pocket up to the 15%. Of course, she challenged that and she lost. But part of the things that the court said there, the court said that she was not honest in her investigations. She did not conduct herself honestly. And of course, this is what later had charges of perjury level against her, to say the entire investigation was termed to be flawed and she acted dishonest in terms of what the Constitutional Court found earlier on.
Advocate, I mean, we know the case has been delayed for quite some time now, with the former public protector even trying to review the decision to prosecute her initially by the NDPP. She had even argued that this charge should be withdrawn because, as you remember, the other one, there was just one charge that was actually withdrawn due to said confusion about her meeting the president or the office of the presidency. So at this stage, another postponement. What for?
Well, Alicia, it has not been in the public domain. I've not been able to follow today's proceedings, but I'm however aware that this matter has been postponed several times, where Advocate Mkhwebane had initially indicated that the proceedings should be stayed while she tried and challenges what the National Director of Public Prosecution was the decision to proceed with the two charges. But of course, if you look at the elements of perjury, it should be something that it's a statement that is alleged to be untrue, made to a competent person under oath, and of course with intention to do a wrongdoing. And I'm of the view and I'm of the understanding that it could be that with relating to the two charges, the National Prosecuting Authority could have found this element on their side, and they are reasonably convinced that if they go on with the prosecution, they will be able to convict. And as to the withdrawal of the other matter, she was afforded an opportunity to make presentations, and after that, I think the NDPP was convinced that that could suffice into an explanation to say there was an acceptable omission, which then led to the withdrawal of that particular matter. But of course, we are aware that the National Prosecuting Authority is continuing with the two charges of perjury.
You know, you mentioned a very important element to this, Advocate, besides your elements argument there, that the fact that there's not much on her appearance in court today. So basically, just like other cases, it's going to basically get lost in the system because so many postponements and delays that the public generally just forgets about what the initial charges actually were pertaining to. So let's talk about the seriousness of this matter then, Advocate. Let's say, for example, the court finally finds her guilty or finds in her favor. What then?
Well, it's one of those serious matters, and you'll remember that this is not the first time There are other high-profile cases where people were found guilty of perjury. It's termed and is deemed in law to be a very serious offense, and of course punishable through imprisonment, of course, and depending on the complexity of the matter, she can also be ordered to pay fine. You'd remember that there was also a case relating to the former Minister of Social Development where she was found guilty, of course, of perjury. And if she was to be found guilty in this particular matter, besides imprisonment, Advocate Mkhwebane is an officer of court, and you'd remember that in terms of the code of conduct or that regulates legal practitioners, they are deemed to be expected to uphold a certain level of higher standard of ethical conduct and honesty. And this may also be, if she's found guilty, of course, be the genesis of some of the processes that may be run by the Legal Practice Council to really determine on whether or not she was able to act in accordance with the oath of office of being an advocate who is a legal practitioner and an officer of court.
Thank you so much for that clarity, Advocate Abigail Ngobene, the legal analyst on the perjury case against former public protector, Advocate Busisiwe Mkhwebane.